If you use a computer, a desktop, a phone given by your employer to communicate personal details, to store personal information there, the employer has a right to pick that gadget, whether it's a phone, whether it's a camera, whether it's a laptop, whether it is a notebook, whether it's anything. You cannot stop it. And you cannot claim that it was a violation against my privacy under Article 31. If you want to have your right to privacy, buy your own laptop. If you want to have privacy, use your personal email on your personal handset. Any gadget you have been given by the employer has a right to inspect. Welcome to Court Helicopter Explainer. Today, we are dealing with implements for work, tools for work. For lawyers, they are given books to use to do research. For media personnel, they are given cameras to work. For people in banks and other places, your employer will give you a laptop. For other employees, you can be given a phone, a handset to use for work. For a watchman, you are given a rungu and a spotlight. And very many implements that the employer provides you for the purpose of doing your job. So the question that we are asking, does the employer have a right to manage those issues that they have given you? Can an employer pick your laptop that was given by the employer and check your personal data, your personal images? Remember, this is the laptop that you have been assigned to work for. You put in your emails, you put in your nudes, you put in your pornographic sites, you put in your personal letters to your boyfriend, to your girlfriend, to your children, to your what? Can the employer access that personal information inside your laptop? But in quotes, the laptop was given to you by the employer. This is a question that Bramwell went to the Employment and Labor Relations Court at Nairobi and found a case number E953 of 2022. This is a matter between Lucy Washeke Gatere, the claimant, versus Royal Tulip, Kana Nairobi, Varum and Varum Arola. This is a judgment by Justice Macau on the 21st July 2026. What are the facts of this matter? In paragraph 66, the claimant contends that her work desktop was seized without allowing her the opportunity to clear and log off her emails with the sole motive of illegally accessing her personal data. The respondents contend that the inspection was lawful as the computer was the property of them and the inspection was necessary to investigate the double booking incident. The facts of this matter is that the employer had bought a desktop computer for use by their staff. So there were issues about double booking. So the employer walked in and picked the desktop. The employee was not allowed to switch off her personal emails and log off whatever that she was doing. Is that lawful? Can an employee do that? Paragraph 71. The judge says, I have considered the evidence on record. The claimant admitted in her supplementary witness statement that she had configured her personal email on the work laptop. The claimant also admitted in her evidence that the respondent had configured her work email account into her personal mobile phone. So she had configured the desktop to have her personal mobile phone and her email. Paragraph 72. The inspection of the claimant's work computer was triggered by the double booking incident to determine whether the claimant had been checking her emails and the event's calendar. The inspection actually revealed that the claimant had not been checking and responding to work emails, had been sending wrong banquet event orders. So this is what happened. What did the judge find? The inspection was lawful, proportionate, and conducted for a legitimate business purpose. Therefore, the claimant cannot scream violation of the right to privacy if the employer stumbled on personal information during the said inspection. Paragraph 74. It follows that where an employee, like in the instant case, uses office computer for personal business, he or she cannot succeed in a claim for infringement of privacy if the employer exercises his prerogative of inspecting the computer to verify its usage by the employee. Amber light must always start blinking whenever an employee starts to communicate private matters through the employer's official emails and or through official computers when he uses the official computers for storage of personal data. The thunder, the killer punch for all employees is in paragraph 75, where the judge says, having found that there is no privacy in the data or communications done through the employer's computer, I hold that the respondents did not violate the claimant's right to privacy by inspecting the work computer. What are the lessons in this matter? The judge is saying, if you use a computer, a desktop, a phone given by your employer to communicate personal details, to store personal information there, the employer has a right to pick that gadget, whether it's a phone, whether it's a camera, whether it's a laptop, whether it is a notebook, whether it's anything. You cannot stop it. And you cannot claim that it was a violation against my privacy under Article 31. If you want to have your right to privacy, buy your own laptop. If you want to have privacy, use your personal email on your personal handset. Any gadget you have been given by the employer has a right to inspect. And the employer can pop in anytime, whether it's he or she, and pick that laptop, check what is going on. This is a wake-up call to the young people. Differentiate office equipment from your personal equipment. Your boss has a right, without notice, to pick that phone and check what you are chatting. Why should you chat? Why should you communicate with employers' property? Yet you went there and you are given that implement for use in the office. Many people are using office internet, office Wi-Fi, and mostly the Wi-Fi is connected to the computers of the office. You cannot use it on your own gadget. So you steal from the employer because the employer has given you a laptop. Today, from Court Helicopter, we bring it to you, courtesy of Bramwell, that if any information in a laptop that belongs to the employer, that information is owned not by the employee, but that is information owned by the employer. I know this one will annoy so many people, but as we said from Court Helicopter, our business is to get the law and tell you how the law is. This is a judge of the High Court, Employment and Labor Relations Court, has given you. You have no right to claim privacy when you are using a laptop of the employee, of the employer. Wakili Dan Sanumari. Thank you.